Declined to answer on the grounds that my answer might tend to incriminate me.
The Fifth Amendment was passed by Congress September 25, 1789, and ratified December 15, 1791. The Fifth Amendment provides some of the most important fundamental rights that an individual has in legal matters, relevant to both criminal and civil proceedings. The Fifth Amendment is important because it addresses the rights of persons, mainly in the context of the criminal justice system. It is one of the most important amendments in the Bill of Rights. And the Fifth Amendment states that no person shall be held to answer for a capital or otherwise infamous crime, unless on a presentment or indictment of a grand jury, except in cases arising in the land or naval forces, or in the militia, when in actual service in time of war or public danger. Nor shall any person be subject for the same offense to be twice put in jeopardy of life or limb, nor shall be compelled in any criminal case to be a witness against himself, nor be deprived of life, liberty, or property without due process of law. Nor shall private property be taken for public use without just compensation. The Fifth Amendment pertains to 5 clauses. Number 1, the grand jury. A jury must determine if there's enough evidence to charge someone with a crime. Number 2, double jeopardy. A defendant can't be tried more than once for the same offense. 3, no self-incrimination. A defendant can't be compelled to testify against himself. 4, due process. Restricts the federal government from unfair practices in criminal and civil cases. And 5, just compensation. The government has the power to take private property for public use. However, the person must be paid fair market value for the property. The grand jury provision, the double jeopardy provision, and the privilege against self-incrimination all have a common history, and that is in England at a time in which the king tried to assert power by bringing people to trial for charges that the king wanted, and the grand jury served as a protection between the king and ordinary people. However, the privilege against self-incrimination goes back a long way. Historically, it started in Star Chamber with John Lynburn. John Lynburn stood up to the Star Chamber in 1637. Star Chamber was an English court that met in secret and sentenced religious opponents of the king to torture. They would call people in and ask them questions like, "Did you commit this crime?" Well, they had no good choices. And if you said yes, they tortured you. If you said no, they said you were lying and torture you. If you refused to answer, they torture you until you said yes or no. John Lynburn refused to incriminate himself, and what became a rallying cry in England became a fundamental right in the U.S. Constitution. What changed the way we think about the Fifth Amendment and how it has changed over time can be shown through one of the most iconic Supreme Court decisions ever made. This case was called Miranda v. Arizona. March 1963, an 18-year-old woman was coming home from her job from a movie theater in Phoenix, Arizona, when she was pulled into a stranger's car, kidnapped, raped, and then driven home. She could not identify her attacker, but after piecing together parts of her story, 10 days later, police showed up at the door of Ernesto Miranda. Now a criminal suspect in the case, Ernesto Miranda was taken down to the station for questioning and interrogated for 2 hours until he wrote a written confession. However, the problems in this case was that Ernesto Miranda was never told he was under arrest. Police told him that he was identified in a lineup, and he really wasn't. He didn't know he had the right to remain silent, and he didn't have a lawyer until trial. At trial, Miranda's lawyer argued that Miranda had the right to have an attorney present in the interrogation room, and he should have been told that he had the right to remain silent, but that wasn't in the law. So the trial judge overruled him and allowed Miranda's confession to be admitted as evidence. This meant that he was convicted of rape and abduction and sentenced to 20 years in prison. However, Miranda appealed based on his confession, and it went all the way to the Supreme Court. Chief Justice Earl Warren was the judge that was assigned to the Supreme Court case, and before Miranda, everyone thought the Fifth Amendment really only applied at trial or pleading the Fifth. No one thought that this right applied to the interrogation room when lawyers were not around and most confessions took place. One side was fighting to protect civil liberties in police custody versus the other side that was fighting to give police all the freedom they needed to solve crimes. The Miranda decision split the court 5-4. As a result, Chief Justice Warren read his opinion for the majority. Given Miranda's right against self-incrimination, he said that police have an unfair psychological advantage in interrogation rooms, and they have all the power and can operate in secrecy and can be destructive to human dignity.
You've been holding out, and I want to know why. It'll be easier for you if you tell the truth.
What difference does it make what I say? You've made up your mind I'm guilty.
Are you?
Don't tell me you have any doubts, since you... Oh, I can't, please. Do I have to have those lights in my face?
The court was now creating something new. The court never said anything like this before, and it was called Miranda warnings. Now every police precinct in the nation had to warn suspects about their rights before the interrogation began. The majority in the Miranda decision is trying to level the playing field in the interrogation room and protect the Fifth Amendment right to self-incrimination.